Welcome to the Bail webinar in the Barbra Schlifer Clinic's 5-part criminal law webinar series. This webinar will discuss in detail what bail is and how the bail system works in Ontario. Before we get started, I would like to remind participants that the information provided in this workshop is not legal advice, but legal information only. This webinar will provide general information and is not meant to be used for specific legal matters. Please consult with a lawyer if you have questions about your specific legal matter. Due to the constantly changing nature of the law, the Barbra Schlifer Clinic cannot guarantee the legal accuracy of this information outside of July 2024. The objective of this webinar is to provide participants with basic information regarding bail in Ontario. It is meant to provide participants with quick and easy access to information regarding bail and what it means for an accused person. This webinar will go over what bail is and will discuss what it means for an accused to be released on an undertaking versus what it means when an accused is held for a bail hearing. This webinar will also go over what bail conditions are and why it is important to make sure bail conditions are always being followed. We will then get into how someone can vary or request to change their bail conditions. Lastly, the webinar will talk about the realities of the current bail system and how it can have a negative impact on criminalized survivors. Bail is when a person charged with a criminal offense is released from police custody while they are waiting for their trial or for their criminal matter to resolve. Reasonable bail is a constitutional right in Canada. This means that a person should be released on bail unless the Crown can argue why the accused person should not be released on bail. Under the Criminal Code, bail has three main purposes: to ensure an accused person appears in court when required, to maintain public safety, and to maintain the public's confidence in the justice system. Bail conditions are supposed to be tailored to the accused person's specific circumstances. After being charged, an accused person can be either released at the scene with a promise to appear and with a set of release conditions that they must follow, or they can be detained and taken into custody to wait for a bail hearing. I will outline the details of each one, starting with when an accused gets released at the scene. First, I will talk about what it means to be released on an undertaking with a promise to appear. When someone is charged, in some cases, the police will arrest them at the scene but release them shortly after and give the accused person a piece of paper called a Form 10 undertaking. This means that the person was charged, but instead of being taken to the police station to wait for a bail hearing, they are released with a set of conditions they must follow. In addition to this, the undertaking has a lot of other crucial information that is relevant to the accused person and their charges. This form will also outline the charges the person has against them, as well as the date, time, and location of their first court appearance. It is important that the accused person takes note of this date and time, as missing this court date could result in the accused person being charged with a failure to appear, and a bench warrant could be issued for the accused person's arrest if they do not attend this or any other court appearance that they are required to attend. This form will also contain the accused person's release conditions. It is really important that the accused person follows these conditions, as not following these conditions can result in the accused person being charged with a failure to comply. This could have negative consequences for the accused person's criminal matter, so it is crucial that these conditions are followed until they have been either varied or the accused person is advised by the Crown or their lawyer that the conditions are no longer in place. Another important piece of information that will be on this form is the date and time for the accused person to provide the police with their fingerprints and photographs. This is a requirement of the accused person's release conditions, so it is important that the accused attends at the date and time outlined on the paper. This is an example of what an undertaking looks like and where an accused person can find some of the information discussed in the previous slide. Failure to follow bail or release conditions is considered a breach of those conditions. If an accused breaches their conditions, this can be reported to the police and the accused can be charged for breaching their conditions. Specifically, the accused would be charged with a failure to comply. This can be hurtful for an accused person, as this will complicate their matter more and will not work in their favor with the Crown Attorney. If you feel like you need to, please take this moment to take a break. If you do not feel like you need a break, please skip forward. However, if you feel like you need to take a breath, or go for a walk, or get something to eat or drink, please feel free to pause here and come back when you feel ready to do so. If the police do not release the accused person at the scene under an undertaking, then the accused person is detained until they have a bail hearing. A bail hearing is when a judge or justice of the peace decides if an accused person should remain in custody until their criminal matter resolves or if they should be released. The default position is that the accused should be released unless the Crown can prove why the accused person should not be released. The Crown needs to submit evidence to support this position and address concerns about the accused person's release. It is up to the Crown to establish why the accused should not be released on bail. The accused person is also given the opportunity to provide a plan for their release. The bail plan should explain how the accused will address concerns about releasing them. This includes things like where the accused will be living, who is available to supervise them, information about their job or school courses, and how they will ensure the accused will keep track of their court date. This is not an exhaustive list, and any information relevant to the accused person's release plan should be shared with the court. A principle that applies to all bail hearings and bail conditions is called the latter principle. This principle determines the appropriate form of release for an accused person under the circumstances. The bottom of the ladder has the least restrictive measures that someone on bail would be required to follow, whereas the top of the ladder would have the most restrictive measures an accused person would be required to follow. This principle requires that the accused be released on the least restrictive measures unless it can be justified why the accused person should have to follow more restrictive conditions. When deciding whether to continue detaining the accused, the court will consider whether one or more of the three grounds of detention are met. The first is the primary ground, which considers whether detention is necessary, so the accused person attends court. The next ground is called the secondary ground, which considers whether detention is necessary for the protection of the public. The last ground is called the tertiary ground and considers whether detention is required to maintain the public's confidence in the justice system. I will explain each of these grounds in more detail in the coming slides. As I mentioned in the previous slide, under the primary ground, the court considers whether detention is necessary to ensure that the accused attends their court appearances. The court also considers whether an individual is a flight risk and if they will likely run away once released on bail. To determine whether an individual is actually a flight risk, the court may consider their roots to the community. For example, an accused is less of a flight risk if they have a job and family in the area and prior history of following their conditions. Under the secondary ground, the court considers whether detention is necessary to ensure the protection of the public. An individual is a public safety risk if there is a substantial likelihood that they will commit another offense or interfere with the administration of justice when they are released. To determine whether there is a public safety risk, the court may look to the nature of the offense that the accused person has been charged with, as well as the accused person's criminal history. Under the tertiary ground, detention is required to maintain the public's confidence in the justice system. There are four separate factors to consider when determining if the tertiary ground has been met. They are the strength of the Crown's case, the objective gravity of the offense. This essentially considers how serious the alleged offense is. Third, the circumstances surrounding commission of the offense, for example, if guns, violence, or vulnerable victims were involved in the commission of the offense, and whether the accused is liable for a potentially lengthy term of imprisonment. Other factors that are considered include the age, criminal history, physical and mental condition of the accused, and the impact their crime had on the victim and society. Sometimes a person will get released on bail if they have a surety. A surety is required to supervise the accused person while they are out on bail, as well as ensure their attendance at court and their compliance with any conditions. Sureties tend to be people who have a close relationship with the accused, for example, a parent, sibling, friend, or significant other. A surety must promise to pay a certain amount of money to secure the release of an individual. If the accused is released and breaches their conditions, this can result in the loss of the money put forth by the surety. Now that we've gone over what bail is and the types of release that exist, I will now go over what bail and release conditions are. You can also feel free to pause here and take a break if you feel like you need to step away for a bit. Any person released on bail will have a set of conditions that they must follow. Failing to follow bail conditions can lead to the accused person being charged again for breaching their conditions and potentially lead to the accused person being held in jail until their criminal matter is resolved. Therefore, it is very important that, whether released on an undertaking or released after a bail hearing, that the bail conditions are always being followed. These are some examples of conditions that are usually put in place for cases involving gender-based violence or intimate partner violence. No contact orders are orders to not contact the complainant in the criminal matter. In cases involving children, where discussions around parenting time and decision-making need to be had, communication through a third party may also be ordered. When a no-contact order is in place, an accused person cannot communicate with the complainant either directly or indirectly. An example of indirect communication is trying to speak to the person the accused is not allowed to have contact with through another person. A weapons ban means the accused person cannot possess any weapons. If they do have weapons in their possession, for example, legally owned firearms or crossbows, then those must be surrendered to the police until the accused is allowed to have them back. Proximity restrictions mean that the accused cannot go within a certain number of feet or meters of where the complainant works, goes to school, lives, or places they are usually known to be. These are, of course, not the only conditions a person would be required to follow. There are several other conditions that could be put in place, which depend on the individual circumstances and facts of the case. If an accused person breaches their bail conditions, they could receive further criminal charges for failing to comply with their conditions. They could also be arrested and detained for a bail hearing. For example, if someone was initially released on an undertaking and then breaches their conditions, they could be detained and held for a bail hearing because they did not follow their conditions. So they may not be granted bail because they now have a history of not following conditions. For accused person who had a bail hearing and were granted bail at their bail hearing, but then breached their condition, they will be less likely to be granted bail again because they did not follow their conditions. An accused person can vary or change their bail conditions by making what is called a consent bail variation request to the Crown. For accused persons released on bail, if the Crown consents to the proposed bail variation, the form is sent to the court for consideration by a judicial officer. After After the variation application is considered by the court, the accused or their lawyer will be notified whether the application has been granted or denied. If granted, a copy of the completed form will be sent to the email provided on the form. If there is a surety involved, they also need to agree to the variation. For accused persons released on an undertaking, the Crown will notify the accused or their counsel whether or not the Crown consents to the request for the variation, and a copy of the completed form will be sent to the email provided by the accused. Until the accused person is notified by the Crown that they consented to the variation request, the accused person must continue to follow the existing release conditions. If the Crown does not consent to the proposed variation of the conditions, an accused person may bring an application for a hearing. In January 2023, changes were made to the bail system, which impacts how some intimate partner violence cases are handled when considering bail. These changes were made under Bill C-48 and expanded on changes made to intimate partner violence matters in 2019. Under the new bail rules created by Bill C-48, an accused person who previously received a discharge for an offense related to intimate partner violence would fall under the reverse onus rule. In most cases, the responsibility is on the Crown to show to the court why it is necessary to keep the accused person detained. However, in a reverse onus bail hearing, the burden is on the accused person and their lawyer to convince the court that any risks can be managed in the community. In these cases, the presumption is that the accused ought to be detained while awaiting their trial, unless they can show that they should not be denied bail by showing that there is no just cause for their detention. It is always a judge or justice of the peace who makes the decision on granting bail. These changes can be problematic for criminalized survivors. Discharges are typically used in non-serious criminal offenses and are rarely used in situations where the victim sustained any injuries. A reverse onus for bail is a very high burden to meet for an individual whose criminal conduct was most likely not serious. A woman may accept a discharge even if she is not guilty because it is considered a low-level outcome. The limited duration of the discharge and the lack of conditions may make a discharge appealing even if one is not guilty of the offense. Rather than prove their innocence through an onerous trial process, some women may feel that it is in their best interest to accept a discharge and move on. However, criminalized women may be unaware of the danger of accepting a discharge in the context of future bail hearings. The new rule also does not consider that there is a significant overlap between victims and perpetrators of intimate partner violence. Survivors may engage in aggressive acts to protect themselves or their families. Further, mandatory charging policies have led to the criminalization of women who have sought help from the police and the criminal justice system. Bill C-48 enhances the negative impact of these mandatory charging policies. The knowledge that even a discharge could have devastating future legal consequences could further incentivize survivors to not seek help from the criminal justice system. If you feel like you need to, please take this moment to take a break. If you do not feel like you need a break, please skip forward. However, if you feel like you need to take a breath or go for a walk or get something to eat or drink, please feel free to pause here and come back when you feel ready to do so. Having gone over what bail is and how it functions, now I will review what someone can expect as they navigate the bail system in real time. In recent years, the province of Ontario has seen an increase in accused individuals being detained while awaiting a bail hearing. Of concern is the fact that this has led to overcrowding in jails and has resulted in less than optimal living conditions. One of the most commonly cited problems with our bail system are the wait times. Criminalized women and gender-diverse individuals in Ontario have reported experiencing delays in a bail hearing due to defense counsel scheduling conflicts, lack of availability of court time, and inconsistency in the application of bail across the province. This delay can have numerous negative impacts on the life of the accused in the form of lost income or the loss of employment, loss of housing, loss of social connections, and the need for emergency childcare arrangements or missed medications. Finally, with the increase in the number of conditions imposed, we are also seeing the imposition of conditions that are unrelated to the original matter. This is concerning as the overly intrusive conditions have resulted in these folks being charged with failure to comply, increasing the number of individuals being cycled in and out of the bail system. This can have a significant impact on individuals as this is another charge for them to navigate. Given that a common tactic of abusers is to isolate and control their victims so that they are cut off from their social support system, these individuals may have difficulties obtaining bail, especially where sureties or community ties are required. This can have dire consequences for survivors as they may have no choice but to name those connected to the abuser as a surety. As a result of being misidentified as the primary aggressor by police, survivors may find themselves erroneously criminalized. A number of factors have been identified as contributing to this misidentification, including abusive partners leveraging the criminal justice system to work in their favor, language barriers when communicating with police, or incorrect reasoning on behalf of the police. The misapplication of mandatory charging policies also plays heavily into misidentification. Finally, survivors who have already been involved with the criminal justice system are less likely to be viewed as innocent or as deserving of protection when they are concurrently experiencing domestic violence. As such, criminalized women do not fit into the problematic victim-offender paradigm that make up the criminal justice system. Where these individuals are not recognized as victims, they may be more likely to be identified as perpetrators and thus may be misidentified by the police. For 2S LGBTQI folks, finding a surety can present a significant challenge. Given that individuals within this community are more likely to have strained family and personal relationships, they have lost a potential avenue of social networks that could act as a surety. Given that it's not uncommon for individuals to rely on family members to fulfill the surety role, 2S LGBTQI people can be placed at a disadvantage when it comes to finding someone that can act as a surety. Additionally, no contact orders can have negative consequences for a 2S LGBTQI accused. This is because the 2S LGBTQI community tends to be concentrated in one area, and this area can be quite small. For example, an accused may be barred from attending or being present in community spaces where they know their former partner to be, given the restrictions around where the accused is allowed to be. The accused person has now suddenly lost out on a social and community space that is integral to their identity and well-being. This can be problematic when we consider that, in some circumstances, there are few places where individuals in this community feel like they are welcome and feel comfortable to express who they are. Finally, we know that 2S LGBTQI youth are more likely than other youth to experience homelessness. Research has shown that most of the involvement these youth have with the criminal justice system is connected to their experiences of homelessness and the need to survive under these circumstances. In some cases, restrictive bail conditions, such as not to attend a certain address, particularly if it is a youth shelter, can exacerbate the experiences of homelessness for individuals within this community. Research shows that Black folks are more often negatively affected by the bail system in Canada. Indeed, Black individuals spend more time waiting in jail before their trial than white individuals who are charged with the same offenses. Overall, Black and Indigenous people are more likely than other groups to be denied bail. A study in Toronto found that even when controlling for other relevant legal factors, race remained a significant predictor of pretrial detention and that Black individuals tended to receive significantly more release conditions than non-Black individuals. Overall, research indicates that minorities tend to be subjected to a greater number of release conditions than non-minorities. Moreover, research shows that racialized minorities have higher levels of unemployment, have lower household incomes, and are less likely to have a permanent address, and are less likely to be able to prove strong ties to the community in order to get bail. These factors have all been used to justify either denying bail or attaching more conditions than required. Often, women are sponsored by their abusive partners and spouses to move to Canada. These women move to Canada not knowing English and have no friends, family, or other social networks for support. Their abusive partner takes advantage of their isolation and often utilizes coercive controlling tactics to control the survivor's behavior. They will remove and limit all forms of communication the survivor has to family and friends outside of Canada, such as taking their phone away, monitoring their phone activity, shutting off the internet, or monitoring the survivor's internet usage. Once this happens, the newcomer is charged. They face additional hurdles as they have to navigate a legal system they do not understand with conditions that limit their already limited connections. Often they end up in shelters because they are not allowed to contact the abuser and rely on community organizations to support them during this difficult time. Racialized communities also tend to be over-policed. As a result, these individuals are more likely to be stopped for no reason. As such, they are more likely than other communities to re-enter the legal system on failure to comply charges. Some takeaways from this webinar are that an accused person can obtain bail in two ways, either by being released at the scene with conditions or by being detained and having a bail hearing. There are also 3 grounds that a court will consider when deciding to grant an accused person bail: the primary ground, the secondary ground, and the tertiary ground. It is also imperative that a person follows all of their bail conditions. An accused person may seek a bail variation if they make the request to the Crown. Lastly, how bail functions in reality can be stressful, frustrating, and sometimes even triggering or traumatizing. It is important to take care and seek support from friends, family, or community organizations. This concludes the bail webinar. For more information, please visit the Criminalization of Women Project website.